to make it potable, that is the distinction. ENA as it is used for polish industry, etc., etc. There are several industrial uses. In this context, please see page 53, the chart. Page 53, for my satisfaction. Have a look at page 53. This is how it happens.
Go chart.
Molasses, sugar syrup, or grains. This is the raw material. I'm very clear about it. For any process which is subsequent, this is the raw material. Then preparation, that is adding water and enzymes for fermentation plus grinding in case of grains. Then, my lord, comes fermentation. My lord Justice Oak has the...
Yes.
Then comes fermentation, that is time taken up to 72 hours. Then comes distillation, means to remove water and impurities to get pure alcohol. Then, my lord, we get either of these three things, my lord, depending upon the nature. Absolute alcohol, rectified spirit, only to be used for industrial purposes such as paint, chemicals, etc. Then upon further purification of the RS, it becomes extra neutral alcohol.
Now, you got it. Now, for the purpose of my question, are you all on the same page, page 53 of the chart?
But
now, just 1 second. Look at the right-hand side of your chart, and the three, upon further purification of rectified spirit, ENA, extra neutral alcohol, minimum 96% ethanol, BV. Now, there are two branches. One, industrial use depending upon market conditions or alcoholic beverage. So your contention is that until it becomes an alcoholic beverage, even at the anterior stage, it falls outside the purview.
Not the middle box is wrong. Rectified spirit only for purposes is fundamentally wrong. The middle box. Rectified spirit only for industrial purpose. That is wrong. Because rectified spirit is primary distillation. It can be both. In the old days, rectified spirit was used for country liquor at 26% dilution, 32% dilution. Now with advanced technology, it is ENA. So it is distillation, RS, ENA. But RS for industrial purpose is fundamentally wrong, which is the same error which synthetics made.
No. Synthetic doesn't go into this.
No. Synthetic says RS is equal to industrial alcohol.
Kindly, my lord.
This box is wrong.
My lord, rectified spirit is used. It's very, very hazardous. My lord, this is what the huge tragedies come. Rectified spirit can be used, but its use is a wrong word. Abused. My lord, there are certain elements, my lord, which are mixed.
Sure.
And my lord, when I say depending upon market conditions, my lord, sometimes the requirement of industrial use only two more minutes. Lord, industrial use, when I say depending upon market conditions, some, Lord, depending upon the market condition, from the ENA, they make more, ENA, if the demand is more. Otherwise, it goes into making of on the basis of use. Lord, your lordships may not, Lord, define the term. The definition is it can be capable of being converted into many things. Lord, rectified spirit is used in making not just country liquor, the hooch also, Lord, the hooch tragedy.
All right. We now got the... Yes, Mr. Datta, what do you have to say?
And, my Lord, my apologies to my friend, my Lord, but I got irritated on the 6th occasion.
All right.
That's
all right.
Quickly, my Lord. So, Lordship, I recommend Balsara should be accepted. And para 74 and 77 of synthetics, where they distinguish Balsara on the ground that they did not comprehend industrial use, is not a ground to overturn Balsara. Balsara, consistently, the application of Balsara had created certainty. Synthetics creates uncertainty. I would pray that your Lordship restores the Balsara provision. Secondly, my Lord, my submission is intoxicating liquor is an exclusive state subject, not subject to anything. And I want...
Not subject?
Not subject to Parliament. The word subject to is not there. So, my Lord, Ultimately, there are 40 entries in the state list today.
We'll just take it down because we are.
Go for 5 minutes.
Yes, certainly.
40 entries in the state list. And out of the 40 entries, 13 entries are subject to list 1 or list 3. So virtually, out of 168 legislative entries throughout, general entries, I'm not including tax. Out of 168 general entries, there are only 40 in the state list. And out of 40, 13 are subject to either list 1 or list 3. So only 27 are left to the states. So my humble submission is, entry 8 should be interpreted to preserve the state's legislative competence in its widest amplitude. But when the attorney, when the solicitor, I was just thinking to myself, just a thought came to my mind.
According to you, admittedly, even according to your position, would be outside the field of entry 8.
Outside entry 8, once, not only according to me, according to parliaments after the amendment, once the liquor is removed from my factory, then it comes under parliamentary control. Once it is purchased by the paint factory for making a paint or purchased by a perfume company or by somebody else, I have no control over it. UP government has no control over it. But I'm just giving, suppose for example, I decide, so as a legislative policy, I want to maximize my revenue. I'll say we are not allowing denaturing. Everything should be cleared for IMFL. I can do that. Take Bihar, they'll say no clearing for IMFL, only for industrial purpose because there's prohibition. So right up to denaturing is the state subject. And let us not dilute that is my humble request. I'll come to the next point on Tikaramji. I just wanted to say that in the Para 32 observation, basically Tikaramji UP Sugarcane Act was to be ultra virus, IDR Act and Essential Commodities Act. In Para 32, they say even assuming, if your lordship sees my submission, written submission, which I
You
give.
made the point, even assuming.
Yes, even assuming. I'm saying it is not obiter. It is Article 141. What Justice Bhagwati is saying is, even assuming 18G is there, unless there is a notified order, the state's power is not taken away. It is not obiter. It is a ratio decidendi. Obiter is something which doesn't fall for consideration. And just it's a passing observation. Now, further, Tikaramji has been accepted to be correct law in Belson, 5 judges, and 3 other cases. That's in my written submission. I've given those 4 cases. So Tikaramji's observation that unless there's a notified order, 18G doesn't operate is Article 141, good law, not obiter. Now just see the Industrial Disputes Act in the IDR Act for a minute and I'll just close my submissions. My lord, in my written submissions, if your lordship takes my written submissions.
Mr. Datta, in case you require 5 or 10 minutes more, please don't feel rushed.
Other friends also. I'll take 5 minutes and I'll give to them because
Since we are concluding, or if you want to come tomorrow at about 3 o'clock, we can wrap up.
we'll finish 5-10 minutes more.
Yeah.
My lord, what I can suggest, lordship, tomorrow at 3 o'clock, the others can reply, my lord.
Not there tomorrow. So let's conclude today. We'll conclude today. We'll go a little longer also.
I'm so grateful.
We'll go a little longer, but all of you don't feel rushed for time. We'll go a little longer, no difficulty.
If lordship wants to take a break and come back also, we'll wait here.
We'll do that. Just use the comfort break and come back.
Yeah.
There's an Eid celebration by the bar, but the bar can wait for another 10 minutes.
Yes.
All right.
They definitely know I'll call them a lot. Each celebration. Yes. So, my lord, now what I did was I analyzed this Industrial Development Regulation Act. Now the argument was that 18G per se creates an occupied field. If your lordship now sees my written submission 1O, very interesting. Of all the sections, every section except one section, every section says central government by notified order, by instruction, by notification in official gazette, by rules. Section 20 is the only section which says that on management and control, state law will not operate. Section 20 is the only which your Lordship mentioned last time. Once Section 20 says that management and control is by IDR Act, all state laws get repugnant. But every other provision, your Lordship just see my written submissions. At page 1, it's now 1O. Just take it. Please come to, I made an analysis. Question, but what I've done is I've answered the questions individually. And Lordship will just come to question 3, 18G. Now, may I request your Lordship to see 18G for a minute? 18G for Lordship, you can see the bare act. We all have read 18G1, nobody has read 18G2. What's what 18G1? 18G1. Lordship has seen number of times, I won't read it again, by notified order. Please see 18G2. Without prejudice to the generality of the powers conferred by subsection 1, a notified order may provide for A to H. Now, my humble submission is, today there is no notified order at all. So our submission is the whole field is open to states. Tomorrow, my lord, hypothetically, the notified order may cover only A, D, F. Right. My submission then is, whatever is not covered will be open to the state legislature. Because the notified order has got a scope of covering a territory of A to H. If Parliament chooses to cover only A, B, C and doesn't touch the others, technically nothing wrong.
Except that 18(1) expressly confers the power on the central government.
Exactly. Exactly.
Now, where do the states get their power?
No, if the central government doesn't confer it, because entry 18G is...
I have a little,
no,
a little far-fetched.
No, I'll tell Lordship why.
The central government, before it decides whether to exercise or not exercise the power, has to be satisfied about the conditions precedent which are spelled out in subsection 1. If the central government comes to the conclusion that the conditions precedent are not satisfied and therefore does not exercise the power, the state can't say that, well, I'm taking a different view of the conditions precedent and I'm exercising the power
I don't
because the central government has not exercised.
Your Lordship is right. I will not make such an argument. What I wanted to see, what Tikaramji said.
That's right.
Only to the
Says the states can exercise power only under entry 33 of list 3.
Exactly.
Because in respect of a controlled industry.
Exactly.
Except for the fact that to the extent to which the field under entry 33 is covered by the IDRA,
yes. Because
now we are very clear that 18G is an exercise of the legislative domain under entry 33.
Same language
right?
is used here.
Therefore, once 18G has occupied the field, then the states cannot say that I will bring about other legislation or exercise power under 18G because the central government has not exercised.
No, I don't say that. 18G is a central act. There is no question of
Obviously.
exercising powers in the state.
So you are saying that the state can then enact a law.
No, I'm saying that entry 33 is concurrent list.
Right.
So trade, commerce, production, supply, distribution is both parliament and state.
Right.
Entry G, 18G, the power to prescribe except production, they don't touch production. All other things, the state can make a notified order. The argument of the union is, once 18G is there, that is enough. According to me, because Lordship will kindly see, when Parliament makes a law, it can either make a law fully, which is fully operational per se, like the Income Tax Act or Central like GST, it is fully operational, nothing is required. It can make a law which has to be implemented through a notification, through a notified order, subject to rules. So in that case, the law is still not there. The law, only the power is there, but it's not exercised. I am putting for the...
But except for the fact, conceptually,
yes,
a failure, or let me not use the word failure, the absence of a notified order by the central government may be an indicator that the central government as a delegate of parliament does not consider it expedient to regulate that particular aspect.
Yes. In fact, I was going to tell you...
At this stage.
Yeah. No, in fact, Lordship will kindly...
In which case can the state say that, well, because this falls in a concurrent list subject, though Parliament's delegate has come to the conclusion that it is not expedient to regulate for a variety of reasons, the state will still regulate. That may be a little far-fetched.
No, what I'm submitting is, Entry 33 must be read with entry 26 and 27. Supply distribution is open to the state legislature, subject to entry 33. What happens is, once a notified order comes, it becomes an occupied field in entry 33, and it's a no-go zone for the
But
states.
until the stage of a notified order, there is no occupied field.
There is no occupied field.
The doctrine of occupied field is not dependent on the administrative exercise of power.
My lord, I'm only
It is
submitting.
postulated on the existence of a legislative instrument.
I'm submitting, my lord, the doctrine of occupied field should not be mixed up with the doctrine of occupiable field. Occupied field means Parliament has occupied that field.
It has occupied the field by legislating, not
Sorry.
by providing for an administrative order under the
No, I'm just leaving the lordship interpretation.
that conceptually it makes very difficult. to accept.
Please see conceptually. Please see conceptually. Entry section 20, they clear bar of the states. Now there are many cases, management takeover, etc. is there. Many things of regulation, other provisions are there. We are only concerned with 18G.
Yes.
Only 18G. I am submitting the entry 33 will prevail over the state's power under entry 25 or 26 of list 2. Lordship will just take entry 25 of list 2, which is subject to entry 33.
And
State
26,
list.
26,
Yeah, 26, 27.
Yeah, 26, 27. So trade commerce within the state, production supply within, of course, within the state will be subject to entry 33. So I'm only submitting that if entry 33 has not been exercised by Parliament by issuing a notified order under 18G, my powers under entry 26 and 27 are there.
so long as a notified order is not issued.
Not there, because what I'm submitting is in a law made by Parliament must necessarily mean a law made by, how does a Parliament make a law? It may make a law per se, or it may make a law which is implemented through a notification. If the notification is not there, no. In taxing laws, we say a lot. If the computation provision is not there, there is no charging provision. So if there is no prescribed rate, there is no duty. So I am only submitting your lordship. Entry 18G, that's why Tikaramji, I use the word occupiable field.
So, Mr. Datta, is it your contention that today, because there is no notification,
Ah.
state can legislate on subjects touching 18G? Can there be a state legislation dealing with the aspects covered by 18G today?
Yes, my submission is take, for example, milk products. Take entry
Today
27.
there could be a state legislation touching the aspects covered by 18G.
Yes, scheduled industry it can be. So please take the scheduled industry, my lord.
So what you are effectively arguing is this, that if there is no notification under section 18G, the subject falls under 26 and 27 of the.
I'm not saying, no, that will be a wrong argument. I'm not making that argument. See, lordship will kindly see the Industry Development Regulation Act covers 39 industries under the scheduled industry. The schedule covers 39 types of industries. Now, the center can occupy that field by issuing a notified order under 18G. It can control supply, distribution, trade, commerce. No problem on that. Today, center has not done it at all.
But your argument postulates that the occupation of the field ensures only when the center has issued a notified order.
Yes.
The answer to that is that the occupation of the field operates at a stage anterior when Parliament has legislated.
No, that's the point I'm making. I'm saying Parliament can occupy the field. It's an occupiable field. Please see the schedule, my lord. Please
It's an
see
occupied field.
No, my humble
The
submission
implementation
No.
cannot be equated with the.
Lordship will just kindly see if my.
We'll consider it, but that's a.
No, Lordship will just.
One last point on what the solicitor was saying, and then we can ask the others to argue. On at what point is that does a jurisdiction kick in?
Yes. No, just see the schedule for a moment.
Yes.
Now let's take, for example, take entry 27.
The last part may not be a very correct.
Anything else left on written submission? Now, Lordship, kindly see entry 27. For example, food processing industries, canned fruits, milk foods, malted foods, flour, etc. Now, 2 points I'm going to make here. I'm saying that suppose there is no notified order with regard to milk foods or canned products. Why can't the Tamil Nadu government or let's say Maharashtra government make a law regarding distribution of mango, say for example, regulate it within that state. There is no notified order. But tomorrow Parliament says that with respect to canned mango slices, this is the law. Maharashtra's power is gone. That's why I use the word occupiable field and occupied field, because there must be, that's why Tekaram says there must be a repugnancy in fact, not a de jure. It should be in fact. Otherwise, what will happen? The danger is Parliament will make a law under entry 3 and never implement it. You will paralyze the state legislatures. And if your Lordship kindly sees, there are 46 items in list 3. Technically, Parliament can make a law with respect to any of these lists and not bring it into force.
No, but food industry, it is a declared industry. The
Exactly.
Food Safety Act.
No,
FSSA, it's
no,
a declared industry.
No, I'm on a different point.
352, it is a declared industry.
Understood. Nobody disputes that. I'm answering my Lord Chief Justice's question. That is it your case that a state can make any laws with regard to these scheduled industries? My answer is yes. Say for example, take for example glass, ceramics, timber, plywood. The state can regulate timber, but if there's a notified order, quit timber, then I have no power. But if there's no notified order, why can't me within Tamil Nadu or Maharashtra make laws regarding movement of timber products? And the whole irony is the surprising thing, it's now become a center state issue. This act from 1979, there is no rule. We are arguing on a law which is not being implemented at all. The strangest irony is that after 1979, and Lordship will see at the end of the footnote, there is no rule made under this act after 1979. In the 2019 Lordships of only 4 items are now regulated.
For licensing.
For licensing. This is only licensing. So what is legislatively progressing, they want to bring it back judicially in the reverse gear. With great respect, we should not do that. If Parliament has chosen, it has made the law. It has chosen not to occupy the field. It's saying the states, you please do whatever you want. We respect your autonomy. But if there's some emergency, I will step in and regulate food, soaps, timber, etc. No problem. But I am saying today that if there is no 18G order,
those industries which have been exempted today, they can always bring back.
The
exemption can be withdrawn.
we don't know what will happen tomorrow. My Lord. Suppose there's some serious deforestation.
Yes,
Yes. Who thought of COVID? Yes. So the final point I'm making.
State will be acting under entry 33 list 3.
No. The state will be acting under entry 26 or 27. What I'm submitting is when the state is regulating, let us say, for example, Maharashtra mangoes. Suppose the state is regulating the canned fruit products or milk products in Bombay. It will be acting under entry 26. Show that. 26 or 27. Trade commerce within the state, production, supply, distribution of goods. The Lordship said goods includes raw materials.
Center
Until 33 kicks in. So 26, 27 operate full vigor till a notified order kicks in under 33. That's my humble submission.
Point when
Yes.
what the attorney or the Solicitor General was mentioning, he said that, well, even it's only in respect of potable alcohol.
Yes.
And even the stage of ENA, that states have no power at all, he said. That part you may want to respond
Yes.
to.
Yes. My humble submission is.
Yeah, the chart which he showed us at page 53.
Yes. But I have given my chart at page 12.
Last page of your submissions.
Yeah, page 12, I have given my chart. And in this latest submission, kindly see the last page again. Again, the last page is a chart. In the latest submission, which I
Yes.
where Kerala manual have shown, everything is controlled by the excise manual. Please see the last chart. All these are portable. This corner is denatured spirit. Everything is in the excise manual. It's under chapter liquor. What is happening in portable alcohol is, as per the Law Commission and as per the Parliament is, once it is portable, it is exclusively state's domain. If it is non-portable, it becomes a center's domain. When does it become non-portable? When it is removed from the factory after denaturing. And that denaturing must necessarily be controlled by the states. It can't happen otherwise. Because it's for the state to decide. These are all, as the Lordship Justice Oak rightly pointed.
Of your chart for a moment.
Which the latest
The chart
Kerala
that,
excise manual. So this is liquor.
no, the chart that you have given in your last.
1-0.
One more.
Your latest arguments.
Yes. Not except denatured spirit, ordinary special. Everything else is portable. or fit for, or it can be for human consumption. It's a red box in your lordship's color, I think. In mine, thing it's black.
So according to you, except this denatured spirit, everything is intoxicating liquor.
No, denatured spirit is actually intoxicating liquor, but it becomes unfit for human consumption. It doesn't cease to be. Lordship will kindly see.
It is also intoxicating.
Yes, because if I add methyl alcohol, I'll go blind. But if I add some other denaturant, I won't go blind. I will become sick, but I can get my kick or whatever I want to drink it.
Not used for drinking.
So the hooch strategy is only when you put methyl alcohol, because that illegal person doesn't know what is the denaturant.
The crimson color that you have put on the right,
Yes.
that is on denatured. I think it should have been put on the left side of the column.
No, I just wanted to say.
What about rectified spirit? You say your topmost column is foreign, fermented,
Yes.
and
No.
distilled.
Yes,
Then
but-
distill takes us to whiskey, brandy, rum, gin, vodka, rectified spirit.
Rectified spirit.
And rectified spirit, actually, this rectified spirit should come on top near country liquor, because rectified spirit diluted with water becomes this thing. But this is the manual which they are given. What they have said is, what are the types of liquors? What are the types?
Spirit is
Country
not
liquor is of two types.
No, it's not. Potable
Not portable.
Which one?
Mistake in your rectified spirit is not portable, Mr. Datta.
Rectified spirit is the most portable thing.
Most portable.
And what I'm submitting, why I gave this chart was.
22% of volume.
Control is by the state governments. Purpose was. Lordship will see page 12 of my chart, the first chart which I gave in my first submission, where I said rectified spirit is primary distillation. ENA is secondary distillation. Both at primary stage and ENA stage. Till 90s, it is only rectified spirit. We used to make it, there are two brands UP used to sell, 26% concentration, 32% concentration with a color added to it. It was only rectified spirit diluted with, brought down from 90% to 26%. Now, because of modern technology, it become extra neutral. What do you say when you say 95% alcohol, what does it mean? If you got 1 liter of ENA, only 5% is water. 95% is alcohol by volume. So ENA now has taken the place of rectified spirit, and I'm told by the association that except Maharashtra, most of the states want to convert only ENA to a country league.
We are intervening because for the International Spirits and Wines Association, but purely on facts, because in common parlance, the words which are used is undenatured ethyl alcohol and denatured ethyl alcohol. Lords, undenatured ethyl alcohol is ENA, which as it is, is potable, which is used for a potable purpose. Lords, I buy around my share of IMFL produced is around 50% of the entire Indian market. My Lord's input is ENA as it is, which is coming to my factories, getting bottled and being manufactured, for producing IMFL. Now, undenatured has to be treated with denaturants so as to make them denatured. Once it is made denatured, all my bottlers have common plants. Because what happens is, there's a common distillery. The common distillery will manufacture both ENA. Once that ENA is manufactured, then a denaturant is added. There is an excise officer who's sitting there. I'm paying a license fee. I'm taking a license from the state authorities. A fee is paid. Then, it is being cleared. And once it is being cleared for the paints, etc., then if it is used for industrial purposes on self-assessment basis, I'm paying a union excise duty. Otherwise, everything is under the
No GST. And Lordship, now from 1968 we got self-removal procedure. There is no officer present, but for state excise officer is present. But I clear this, and whatever goes for denatured, that goes to central excise thing. And my friend said that GST central excise, earlier central excise will be shared by the states. Now GST is centered by centrals.
And all these are composite plants, just to give this.
ENA
Product is
told,
finally,
if you
95%
consume
is
ENA as it is, you die. It's toxic. It's poisonous. My learned friend says, no, it can't even be
My friend is
smelled.
going back to this beverage for human
It's not
consumption.
that.
No, please. Lord, rectified spirit is.
Yes, therefore it is used
No.
as toxic in synthetics.
No, but even today under the amendment, rectified spirit is potable alcohol. ENA is potable alcohol. Under the GST, what is not potable is denatured spirit. Only when the denatured is added, it ceases to be potable. Otherwise, everything else is potable. Let us not, otherwise we'll come back to the synthetics confusion. Everything is potable. Only thing is what happens is you can't consume it fully. You have to dilute it and use it. Not even for examples, just to take, I was speaking to some doctors. Why do you suddenly get an intoxication? If the volume and the speed is very high, you get completely intoxicated because the liver can't metabolize it. That's why you get drunk. But if you take 30 ml and drink it over 1.5 hours, nothing will happen to you. That's the whole problem.
That's IMFL, not.
So, Milord, just to summarize, I would say, Milord, now what's happened is if my state's argument is accepted, the industry which is making alcohol, ENA, will neither be under state control nor central. That's the paradox. So I would only humbly submit that please restore the Balsara position. Tikaramji's good law under Article 141. I would request the Lordship to consider this theory of occupied field and occupiable field. Secondly, Mar Aprem Kuri has to be overruled. Because Mar Aprem Kuri did not consider Belson sugar. Belson sugar says, till you bring it into force, it is not law. It's a 5-judge bench. So Mar Aprem, apart from being per incurium, not considering a coordinate bench.
Mar Aprem is 5-judge again.
Coordinate bench should have considered it. And Lordship will just see the danger to federalism if you have the theory that just making a law eclipses the power of the states. The power of the state is eclipsed or taken away only, not only when the law is made, if that law requires a notified order or the law requires a notification or a rule, that complete process must be done. Only then occupation takes place. Deeply obliged.
Thank you, Mr. Datta.
Sorry, Milord, in case we have used a high decibel because it was.
No, between us, there are never high decibels.
Yes, sorry.
Milord, would your lordships be taking a break now, Milord, or should I start?
No,
I can finish in 10.
Yes, we'll continue.
Will. Milord,
Just suggesting what should be left. We need about 10-15 minutes. Right.
Financial implications for all the states. Huge, huge.
This
Because
attention
after
has been
synthetics, you're
taken.
not able to collect any vent fee.
At 4 o'clock, Milord.
A 5-minute break and come back, I think, because Tuesday. Come back in 5 minutes. We'll just take a small break, just a comfort break, and we'll come back. We'll hear you and entertain themselves until we arrive there.
But in case I'm not there I'll try to be here as much as I can.